State ready?
Yes, sir, Your Honor.
Defense ready.
Your Honor, before we bring the jury back in,
Okay.
there's an issue that we need to take out.
All right, I hear you.
Your Honor, just now, the defense received exculpatory evidence from one of the minors, BG's, whose phone had been turned over to law enforcement, and law enforcement downloaded contents of his phone. However, these text messages were not provided to us until BG himself provided them to us earlier today. This was a phone that was taken into custody by Zach Cotton on March 19th. If you look at the state Bates numbered document 283 is actually his arrest, the search warrant for that phone. Now, while they did provide us text messages from the day of March 19th, they did not provide us any of the other text messages. BG found these text messages on his phone and texted them to myself earlier today. I printed them out on the lunch break, and according to both the United States Supreme Court case law, Brady v. Maryland, Mississippi, King v. State, and also Arizona v. Virginia, which is a U.S. Supreme Court state, the failure of law enforcement to disclose exculpatory evidence is imputed to the state, and such disclosure mandates either a continuance until the defense has had time to review this documentation or dismissal of the charges themselves for the failure to provide exculpatory evidence in discovery.
You want to mark?
Yes, Your Honor, I would like to mark on Friday.
All right, I'll be marked Friday purposes only.
Can we look at it? Yeah, got your copy right here.
I mean, I have a response in general without looking at them.
Hang on. Take a look at them. What were they marked? 23 ID only.
Your Honor, the date is on the top text message, but the one in general that we believe goes to the exculpatory evidence
Okay.
is on this page. So it would be this page. BG is in blue, Carly is the black.
Where it says do it back? Is that the first text message?
Yes.
All right. So the defendant says do it back. Mr. B says, I don't know what that is. What's going on? She responds, I don't know. I called Anthony because I wanted to talk to him, and then I saw him and I couldn't breathe, and I couldn't say anything because I didn't know what to say, and I can't remember anything that happened today. I zoned out for most of it, and I don't know what's wrong with me. That's what
Yes,
you're
Your
showing
Honor.
is the exculpatory part.
Yes, Your Honor. And that this text thread is dated as of November 22nd of 2023.
All right, anything further from the defendant?
Not-
By way of motion.
No, Your Honor, just that the U.S. Supreme Court and also the Mississippi State Supreme Court is clear about the failure of the fact that it was in the possession of law enforcement. Law enforcement downloaded the contents of this phone, had it by search warrant, and failed to produce it. And that the failure, and according to the U.S. Supreme Court in Arizona v. Youngblood, the failure of law enforcement is imputed to the failure of the state for discovery purposes.
Okay. Response by the state, or do you need a few moments?
I'm prepared, Your Honor. First of all, I don't believe that text message.
Let's step up to the podium.
I may have to go upstairs at some point and get a signed piece of paper from Ms. Todd, but I think that I have it here. Your Honor, first let me address the fact that this is not, in fact, exculpatory material. This is a text message between and the defendant from back in November. Took the stand. He could have provided this at any point. He actually, in fact, spoke to the defense attorneys previously. This is not new information that they had. It's not exculpatory information. However, in order for it to be a Brady violation, the state would, in fact, not have had to produce the material that they had. On June the 4th, 2024, the state of Mississippi provided to the defense attorneys one jump drive containing digital evidence media files, witness interviews of minor friends, the indictment, discovery bait stamps 1 through 349, supplemental discovery bait stamps 350, 351. Third Snapchat report, 352, 356. 2 CDs labeled Heath Smiley hospital interview and Deputy Allison Dufour body cam, and 1 hard drive containing phone dumps. Your Honor, they were in fact provided the phone extraction from Bennett Germany's phone. It is not the state's fault that they did not review those messages. Everything that was on Bennett's phone that was taken from law enforcement was produced to the defense attorney on June the 4th, 2024. Since there had been issues with the state of Mississippi and the defense attorneys claiming that they had not in fact received items, the state went ahead and had them sign something stating that they had received discovery, and also the entire jump drive, now not the external hard drive, but the jump drive that was provided that had the media and electronic data on it was screenshotted. Ms. Todd signed off on April the 20th, 2024 that she had received all those items, including through bait stamps number 798. When Mr. Camp reached out to me the day before the defense attorneys had provided their expert discovery, I believe it's by email, I can go back and look, Your Honor, I believe responding to him around 5 o'clock, he said something to the effect of, where are the text messages between the kids? And my response was, well, there's 2 places. There's screenshots that you guys were provided, and then there's messages within the actual phone extractions. Your Honor, they had this material, they knew this material existed, and for them to try to claim now that they were not provided that information is disingenuous. And again, this witness took the stand. If they knew this, if he knew this, if they had this information, they met with him previously, why on earth would they be producing it now? We do not believe this is exculpatory. This is something that happened back in November. We're here because the state has charged Carly Gregg with murdering her mother on March the 19th, 2024. We are here because the state has charged Carly Gregg with attempting to murder her stepfather, Heath Smiley, on March the 19th, 2024. And we are here because the state has charged Carly Gregg with tampering with physical evidence for removing the surveillance footage that captured a portion of the incident and hid it in the refrigerator. There is nothing about this text message that would indicate that it is anything other than messages between the defendant and one of her friends who on the stand said he was her best friend. This has not been authenticated. I don't know, Your Honor, without going and putting the phone extraction into my computer whether or not this message is actually there. But if it is, they've had it since June.
Hold on a second. In a second. I'm going to give you a chance to reply. All right. What documentation do you have to prove that you turned this over to the defense? I believe you said there was a jump drive that contained the phone extract, and I'm familiar with phone extractions. There's no way to extract part of a phone on Celebrite.
That's right, Your Honor.
Okay. So did you show me what you got to prove that you turned over a jump drive?
Of course,
And if you need a few minutes to go grab your paperwork, you
I
go.
do not, Judge.
Show it to counsel opposite.
We've had this issue come up previously, so now we have the defense attorney sign saying they picked up material.
All right. Do you have a copy of that we can mark for identification?
This is the only one I have, Your Honor. I can rip it out of the file and make a copy if necessary.
All right. You showed it to counsel opposite, correct?
Yes, Your Honor.
All right. Mark it for identification purposes for the state.
Your Honor, for the record, that bears Ms. Todd's signature and date.
Okay. Let's mark it so I can see it. All right, and what you're saying is this jump drive contained digital discovery. Is that correct?
Your Honor, there was a jump drive that the defense brought to our office. That jump drive contained the digital discovery, the physical file, the PDFs, the 2 CDs that we had in our file, as well as we had an external hard drive that had these phone extractions on them. They were put onto the jump drive that Ms. Todd picked up on June the 4th, 2024, as indicated by a hard drive containing phone dumps. Your Honor, there are multiple emails between myself and Ms. Todd that if I need to, I can run upstairs and print off, where I've said, let me know if you can't open a file. Let me know if you don't have something. I said, in fact, hey, I screenshotted 800 pages and scanned it in. Let me know if a single file doesn't open. Mr. Camp and Ms. Todd were attached to all those messages. At no point did they ever say, hey, we don't have this phone extraction. Again, just because they don't know how to access something, they didn't ask our office for something, or they didn't take the time to review that material, Judge, does not put that burden on the state.
Is there anything else the state wants to move in for the court to look at?
Your Honor, I'd like an opportunity to go upstairs and print all those emails I've talked about, if that would assist the court in any way.
Sure. Can you do it within 10 minutes?
I believe so.
All right, we'll be in recess 10 minutes.
In fact,
I'm going to
Mayor-
give you a chance to reply, but I want to see her. It's going to go motion, response, reply, I rule, we're done.
This is not reply was cleared up, Your Honor.
Nope, not till I see her documents. I want to complete the state's response. That way you can have a reply. We're not going to have a reply, response, or reply. It's going to be motion, response, reply, I rule, and the rest of it's up to the appellate courts. All right, y'all got 10 minutes.
Your Honor, I believe that I could probably just make a copy of all of this, and that would entail my emails back and forth with Ms. Todd regarding discovery. I kept them because I assumed that there at some point would be some sort of argument that we hadn't produced something. But I do not have a copy of this. This is just the one copy I kept for my file.
Well, I saw Mr. McDivitt stand up back there. He can make himself useful and cut down on the jury's time. I think everybody in the courtroom knows I don't have a problem abusing lawyers and their staff. So give him the email, the email. Mr. McDivitt, you go copy it.
I think that should be everything. I'm going to make sure that's all of it.
And please bear in mind, I got a jury waiting.
The problem is there's a bunch of staples in there, but I don't know what I got in there. But I'll keep them. Thanks, sir.
All right. Ms. Gugliano, still don't discuss your testimony with anybody. Well, let me ask this. While he's making copies, would there be some objection to us going on ahead and hearing her testimony? I mean, you're asking me to dismiss the charges, basically, Ms. Todd, correct?
Yes.
Okay. Well, if I don't decide to dismiss the charges, we're going to hear Ms. Gugliano's testimony anyway. So rather than wasting the jury's time, I'm going to bring the jury in, let you cross-examine her, let them redirect, and then I can take another break, and maybe copies will be done by then. I'll hear objections to that procedure by the state.
No objection.
Objections to that procedure by the defense.
No, Your Honor.
All right, let's bring in the jury. Ms. Newman, get your notes. Have a seat. Apologize. This is my fault, okay? We have some things that we have to take up outside your presence. I'm going to ask you to go ahead, step back to the jury room for just hopefully a few minutes. When I say a few, 20, maybe 30, and I apologize. This is my fault, okay? So I know it's in and out, but nonetheless, just take a breather. Give us about 30 minutes, all right? Everyone remain seated while the jury exits. I'm going to take about a 10-minute recess, and hopefully the emails will be back before then. All right?
Your Honor, and I found some more. I'm going to go upstairs and get them to add those to the stack.
All right. We'll be in recess till 1:05.
Your Honor, for the record, while we were out, the state went upstairs and grabbed a copy of our external hard drive that had the phone extractions on them. We opened that extraction. It was dated April the 30th. It included Germany's cell phone. We found the messages that Ms. Todd showed the court are in fact on that external hard drive found within the phone extraction that was turned over to them on June the 4th. Ms. Todd is currently in the process. She initially told me she did not have Cellbrite on that file. I showed her on her jump drive where she had it, and she's currently in the process of opening up the cell phone extraction that was produced on June the 4th.
Your Honor, I have it open right now if I can respond.
All right.
Your Honor,
Hold on, time out. Where's the stuff you wanted to mark for ID? Is there any further response from the state?
Well, Your Honor, the fact that the witness took the stand already.
Okay. So let's finish up the response.
Yeah, you're right.
Again, motion, response, reply, I rule. Okay?
Yes, sir. Your Honor, they were provided the information. This witness has taken the stand already. He could have been asked anything that they wanted to about these text messages. Their motion was that it was exculpatory and that it wasn't turned over. In fact, it was turned over. Your Honor, that I don't know any other way to say that they have it.
Okay. All right. You see. Reply by the defense.
Yes, Your Honor. If you'll recall at our hearing on June 4th of 2023, which I have a transcript of, at that day this court told the state to provide all discovery to the state by 5 o'clock that day. The court then asked me if I, in fact, on page 66 of that transcript, the court says, Ms. Todd, do you have an external hard drive you can turn over to the state? And I said, yes, Your Honor, I do. And it said, you owe that to them by 4 o'clock today. And at that point, Your Honor, I did provide an external hard drive to the state before 4 p.m. that day. The state, I think Catherine was just a little mistaken when she said the state gave me these files in digital on the thumb drive. They weren't on the thumb drive. They were on a hard drive, and on the hard drive it contained specific screenshots from March 19th with me. And then in a different section of it, it contained like a summary on the external hard drive of like, sort of looks like this, of text messages. They're not in chronological order. There doesn't really even seem to be a date order, but I did type in one of the words from text message that I gave you on March 28th, which was zoned out, and it's not pulling anything up.
Your permission to assist her?
Do you know how to use the Cellbrite extraction? Do you know how to use the Cellbrite tool, Ms. Todd?
Yes, Your Honor.
So you've looked for it in the reader.
Yes, in fact, it even says here, select the current words, and when Ms. Newman typed it in on her computer, she typed in zone, and it pulled up that particular text message, but it's not pulling it up on this one.
Your Honor, maybe assist her and see if it's in fact on her copy.
Sure.
It's there, Your Honor.
Did you find it, Ms. Todd?
Yes, Your Honor, I did provide it.
So you did in fact receive it.
Yes, Your Honor.
All right. Ms. Todd, I'm going to say this. When you accuse a prosecutor of a Brady violation, if she had in fact committed a Brady violation, it should be terminated. That's a very serious allegation. Now, as far as Brady versus Maryland, this is the court's ruling. First, the court finds that the defendant did receive it. As such, there is no Brady violation. Second of all, the first prong is that the state possessed evidence favorable to the defendant, including impeachment evidence. In fact, what I've read in this does contain impeachment evidence, but it impeaches Mr. and your client. This talks about drug usage back to November of 2023, when their testimony is she didn't begin using drugs in any form till January. Second, that the defendant does not possess the evidence, nor could she obtain it with any reasonable diligence. as this court, in fact, the defendant did have it, and obtaining it with any reasonable diligence. As I recall, Mr. testified that he was her best friend and that he got on a bike and rode several miles to come see her on the day she said she needed help. I think Mr. has been more than available to Mr. Gregg. Third prong is that the prosecution suppressed the favorable evidence. In fact, they turned it over. And finally, that had the evidence been disclosed to the defense, a reasonable probability exists that the outcome of the proceedings would have been different. If I'm being frank, this reads more like she has some crush on some boy named Anthony, and there's a talk of a whole bunch of use of taking drugs and sleeping pills. I don't see where that would create a reasonable probability of a different outcome. And finally, the court would note that the state has no duty to search out and discover all possible exculpatory evidence. For those reasons, the motion to dismiss the case for a Brady violation will be denied. All right. I'm going to give these back to the court report.